Good afternoon, Good afternoon, Firoz. Is everything fine?
Yes, sir. Fine, sir.
Any question from the last class? Any clarification if you wish, if you want?
No, sir.
Okay. So is this PPT and PPT visible? And am I audible?
Yes, sir.
Okay, that's good, Chaitanya. Where were you yesterday?
सर थोड़ा काम था ना इसलिए कल का क्लास में
No. So
सॉरी सर
class देख लिया? Have you watched video?
नहीं सर आज देखूंगी सर कल तो नहीं देखा
Okay.
यस
Hi Arinjai, good afternoon.
Good afternoon, sir.
Good afternoon. How are you?
I'm doing good.
That's nice. I'm also good. So today we will talk about amendment to the Constitution. The process of amendment. Okay. So should we wait? Just 2 minutes. I think I should wait for the others who usually join us. So if any question, if you have, you can just ask. Maybe this Friday I'll give you, multiple choice question, objective type question on DPSP and the fundamental duties and amendment to the Constitution. Because we have not done any question on this part, so we will practice on the objective question. So amendment to the Constitution and basic structure doctrine. That are two topics that we are going to discuss today. So let's start. So amendment to the Constitution, right? So Article 368 in the part 20 of the Constitution deals with the power of Parliament to amend the Constitution. So write down amendment to the Constitution. Give the title de dijiye. Give the title of today's topic and write down Article 368 in the part 2020 of the Constitution deals with CAA, Constitutional Amendment Act. Hi Deepak, good afternoon. Deepak, this is the first line. Today we are doing amendment of the Constitution. So write first point, that is Article 368 in the part 20 of the Constitution deals with CAA, that is Constitutional Amendment Act. So Article 368 has 5 clauses. We will see clause by clause. Second point, you write down Article 368 clause 1, gives power power to the Parliament to add, repeal and change any provision of the Constitution. Any provision of the Constitution. Article 368 Clause 1 gives power to the Parliament to add, repeal, change any provision of the Constitution. Clause 2 says that amendment bill, says that amendment bill can be initiated, can be started or initiated in either of the house. Either of the house. Either of the house of the Parliament. Clause 2 says that amendment bill can be initiated in either of the house. If you have done, then just let me know. Okay. Deepak, Firoz, done? Okay. Either in either of the house of the Parliament, right? And when bill is passed, when the bill is passed in each house, it shall be presented to the President of India. For assent. Now President of India shall sign on it, and then the bill will be, the Constitution will stands amended. When bill is passed in each house, it shall be presented before the President of India for assent. To the bill. Once the President sign, it stands amended. It means Constitution stands amended. Done? Okay. So did you get the point how a Constitution amended? Firoz?
Yes, sir.
Yeah. Tell me what is the procedure for constitutional amendment?
Sir, Article 368(1) gives power to the Parliament for the change. So for the change, the amendment bill can be initiated in any of the houses.
Right.
Yes, sir. And when the bill is passed in each house, it shall be present to the President of India for assent. And then the
Right,
President
right.
signs the bill is passed. Yes, sir.
Very good. Very good. Now, the clause 3, इसी में ऐड करना है. Clause 3 says that Article 13 shall not be applicable, in the case of CAA, यानी Constitutional Amendment Act. Clause 3 says that Article 13 shall not be applicable in the case of CAA, Constitutional Amendment Act. Clause 4 says that CAA would not be questioned in any court of India. Any court. CAA would not be questioned in any court. And clause 5 says that there shall be no limitation. There shall be no limitation on the power of Parliament to amend the Constitution. There shall be no limitation on the power of Parliament to amend the Constitution. That is 5 clause. The 5 point it says. First says, अब पहले लिख लीजिए. First you finish it, then. Done? Okay. If you're done, then fine. Now you see the clause 368, Article 368 was not so vast, right? But it was the Article 368 itself amended, you know. लिखिए, next point, I think second या third point होगा. अगर third point है तो third point लिखिए. Article 368 itself, Article 360 was amended itself. Article 368 was amended by 24th CAA and 42nd CAA. Article 368 was amended, so power of Parliament को ही amend कर दिया गया. 368 जो amendment का power देता है Parliament ने उस article को ही amend कर दिया, right? Yes, Prince. Good afternoon. So, have you finished this third point? The fourth point is that clause 1, 2, and 3 were modified just for the sake of information. Modified in 24th amendment and 42nd CAA added clause 4 and 5 that we have already discussed. Finish this. Article 368 was amended by 24th Constitutional Amendment Act and 42nd Amendment Act. Clause 1, 2, 3 was modified in 24th Amendment Act and 4 and 5 was added in 42nd Amendment Act. Done. Firoj, Deepak, Arinjay, if you have done, then let me know. Okay. Prince. Now so that is power of amendment to the Indian Parliament, right? Power to amend the Constitution. Now let's talk about type of amendment. So in the amendment, right, there are many types. So there are many provisions in the Constitution for which we need a simple majority, right? But there are few provisions for which we need absolute majority, and there are effective majority. So there are three kind of majority here. Basically, four kind of majority: simple majority, absolute majority, effective majority, and special majority. Special majority are four kinds. We will discuss now, right? First, see what is simple majority. There are four kinds of majority, right? First is simple majority. There are many provisions in which Constitution can be amended by simple majority. For example, Article 2 and 3, creation, abolition, alteration of the state, changing name of the state, abolition and creation of the legislative council in the state, 2nd, 5th and 6th schedule, quorum in the parliament, parliamentary procedures, citizenship, delimitation, money bill, etc. Not it down. इसको लिख लीजिए. Simple majority means there are many provisions that in which the parliament need a simple majority. So what do you mean by simple majority? For example, if there are 100 member present in the parliament, what would be the simple majority, right? कितना होगा सिंपल मेजोरिटी में? प्लस 50 + 1, अगर 300 अगर मान लीजिए है तो कितना होगा? 151. अगर 300 मेंबर पार्लियामेंट में मौजूद हैं लोकसभा में, तो लोकसभा में मेजोरिटी कितनी चाहिए? 151. मेजोरिटी मतलब होता है 50 + 1, मतलब 50% + 1. Fine, clear? Note it down. Simple majority, there are many provisions in the constitution that can be amended by simple majority, like abolition, creation, alteration of the state, citizenship, delimitation, changing the name of the state, 5th, 2nd, and 6th schedule. Right? Done? Should I start second one? Absolute majority. What is absolute majority? Okay, I'm waiting. Note it down.
Done, sir.
Okay, very good. Very good. Prince, Firoj, Deepak, Arinjay, let me know if you are done. If you have written. Okay. I hope everyone has written now. Okay. So what is absolute majority? Second is absolute majority. Absolute majority needs the 50% of the total strength of the parliament, right? Of the house and plus one, right? That means अगर 545 है तो 50% कितना हुआ by 2 plus 1 कितना होगा 273. So that is absolute majority. 50% of the total strength plus 1 is absolute majority. Simple में क्या था 50% of the present, total strength नहीं. Simple majority में क्या था 50% of the present and plus 1. यहाँ पर क्या है 50% of the total strength plus 1. That means अगर मान क्या लीजिए होता है 545 पार्लियामेंट का स्ट्रेंथ है लोकसभा का by 2 कर दिए एंड प्लस 1 कर दिए तो मेजॉरिटी चाहिए 273, राइट? ये कब यूज करते हैं, कब होता है ये? जब आप देखेंगे कि कोई सरकार बनाने के लिए कोई पार्टी क्लेम करती है तो कहती है कि मेजॉरिटी ऑफ द हाउस है उसके पास, राइट? कोई भी स्टेट गवर्नमेंट हो चाहे पार्लियामेंट में हो, राइट? तो वो ये मेजॉरिटी प्रूफ करती है 50% ऑफ द टोटल, राइट? 50% ऑफ द टोटल एंड प्लस 1 कहीं पे भी गवर्नमेंट बनाने के लिए, राइट? अदरवाइज और यूज नहीं होता है. किसी भी पार्टी को अगर स्ट्रेंथ है उसके पास, जब हंग असेंबली होती है तो ये बहुत चलता है. अभी एमएलए को पकड़ के ले जाते हैं बड़े बड़े हाउस में, बड़े बड़े छोटे होटल में रखते हैं. हो जाए तो बताना, अगर समझ ना आए तो भी बताना. डन? समझ में आया ना? Is it clear? It is used, when there is a hung assembly, right? So जब अलग अलग पार्टी क्लेम करती है सरकार बनाने के लिए तो गवर्नर बोलता है कि ओके मेजॉरिटी आप साबित कीजिए, ओके यू प्रूव योर मेजॉरिटी. और अपोजिशन चाहता है कि जो जिसके पास कम होता है वो चाहता है कि मेरे पास आ जाए. Anyway, so you must have watched the drama in Karnataka, in MP, in Maharashtra, right? Now come to effective majority. What is effective majority? Now in Haryana, is that I'm not reading newspaper from 1 week. I think okay. And I think Uttarakhand CM also has resigned, but I think they have majority. They have it. Now come to the effective majority. What is effective majority? Effective majority means total member of the parliament minus vacancy. मान लो कोई मर गया, इलेक्शन हुआ, उसके बाद ही खत्म हो गया, तो हम क्या करते हैं, टोटल मेंबर माइनस वैकेंसी बाय 2 and then plus 1, right? Total members minus vacancies by 2 minus 1. For example, 545 है और 5 का डेथ हो गया है, तो 5 हम इसमें हटा देंगे by 2, right? and plus 1. इसका कितना हो जाएगा, 540 by 2 plus 1, यानी ये हो जाएगा 270 plus 1 is equal to 271 would be the effective majority. So, for example, in removal of the Vice President, Speaker and Deputy Speaker of the Lok Sabha, this majority is being used in Indian Parliament. Any confusion? Let me know. We can resolve that confusion. If you have done, then let me know so that I can proceed ahead. I can move ahead. Very good. Chaitanya, what is effective majority?
Sir, total member of the parliament minus vacancy divided by 2 plus 1.
Plus 1.
That is effective majority.
Okay. You got it?
Yes, sir. Yes.
Okay. Very good. Very good. Now there are the fourth kind of majority, that is special majority, and इसमें भी there are 4 types of special majority, right? There are 4 types of special majority. What is that? So first type is a special majority. आप ऐसे लिख लीजिए 249, आपको याद रहेगा. स्पेशल मेजोरिटी अकॉर्डिंग टू आर्टिकल 249. What does it say? It says 2/3 present and voting. 2/3 प्रेजेंट एंड वोटिंग. मान लीजिए कि 345 है राज्यसभा का मेंबरशिप, 45 प्रेजेंट नहीं है. कितना प्रेजेंट है? 300, राइट? 2/3 300 प्रेजेंट है, तो 2/3 कितना होगा? 2/3 यानी कि 100, यानी 200 मेजोरिटी होने के लिए चाहिए. यहाँ प्लस 1 नहीं होगा, आई कंफ्यूज. प्लस 1 होगा. 2/3. No. Yes, Deepak, do you want to say anything?
सर इधर +1 की जरूरत क्यों चाहिए जब 2/3 की मेजोरिटी है ये?
राइट 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 राइट, +1 नहीं चाहिए यहाँ पर। मैं खुद चला +1 क्योंकि आगे आगे +1 लग रहा है ना हर जगह, तो यस। So you got the point? So for example, you know, creation of all India services. What is Article 249? Article 249 gives a special power to the Rajya Sabha, right? Right. According to Article 249, this bill can be introduced in the Rajya Sabha and it must be passed by the 2/3 of the member present and voting. Like GST भी इसी से, GST, you know, all India services, any matter in the state list, any matter in the state list. अगर स्टेट लिस्ट पे पार्लियामेंट अगर अमेंड कुछ बना रही है तो they need a special majority as per Article 249. That means 2/3 present and voting. Arinjay, got the point? Yeah. Arinjay, can you tell me what is a special majority? Of the first
President voting members.
Awaz, your voice is not. Yes, can you repeat? Yeah.
So it is essentially 2/3 of the total present and voting members of the House.
Of the House, right? Very good, very good. Everyone, Chaitanya, you got the point?
Yes, sir.
Prince, Firoj, got the point? Okay, if you got the point, then let's move. Right, the second one. A special majority यहाँ पे लिखिए 368 as per Article 368. A special majority as per Article 249. A special majority as per Article 368. What does it mean? You know, 2/3 present and voting, PB, right? And that should not be less than 50% of the strength of the House. Special majority as per Article 368. 2/3 तो होना चाहिए present and voting, but that should not be less than 50% of the House. 50% of the House. That is a special majority as per Article 368. If you're done, then I'll give you an example. Special majority as per Article 368. It says 2/3 present and voting, and that should not be less than 50% of the total, you know, of the House. Okay. So, for example, yes, done, Deepak? Okay. So, for example, मान लीजिए कि 300 लोकसभा में, LS में 300 लोग, 300 मेंबर पार्लियामेंट में प्रेजेंट है, राइट? और इसमें से 200 लोगों ने यस में वोट किया है और 100 लोगों ने नो में वोट किया है, तो ये पास माना जाएगा कोई भी कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट? 200 लोगों ने वोट किया है तो 2/3 कितना हो जाता है? 2/3 कितना हो जाता है? 200.
सब
हाँ
सर टोटल स्ट्रेंथ तो वही ले रहे हैं ना हम लोग 545
545 लेना होगा। यस, हाँ बताइए मुझे, आप ही लोग बताइए तो अच्छा रहेगा, फिर हम लोग। Yes. So if parliament strength is 300 that day particular, मान लीजिए आज, और कोई amendment पास हो रहा है as per 368 और 200 ने yes वोट किया and 100 ने no वोट किया, will it be passed? No. Why? Why? Firoz, why it won't be considered as a passed? Yes, it is less than, the strength is less than 50% of the total member of the house. That's good. So okay, so what is the minimum number? 2/3 भी होना चाहिए, 50% से ऊपर भी होना चाहिए, कोई बताओ। But 2/3 भी होना चाहिए दीपक, it should be 2/3, and if you see 273 then it is half plus 1. Now calculate, 2/3 होना चाहिए and 50% से ऊपर होना चाहिए, calculate it, you have number 545. मान लीजिए मान लीजिए 400 लोग प्रेजेंट है, 400 लोग प्रेजेंट है और 350 ने वोट किया यस में और 50 ने किया नो में, पास होगा? नो। Yes, Arinja, what do you want to say? 408 minimum presented voting. Okay. So let's see कितना होना चाहिए। मान लीजिए 500 लोग प्रेजेंट है और इसमें से कितना, ओके अभी एनडीए के पास कितना मेंबर है? अभी 383 इन द लोकसभा, इफ आई एम राइट, 383 or 384, 385, I don't know, that might be 383. Anyway, let's say 383 and वहां पर लोग प्रेजेंट है 530 के आसपास, थोड़ा सा इसको हम बदल देते हैं 530। अब 383 ने यस में वोट किया आउट ऑफ 530, will it be considered as an amendment to the constitution? Yes. Yes. So 2/3 कर लेते हैं इसका, 383 and बट्टा 3 into 2.
सर
हाँ
सर 383 का 2/3 क्यों 2/3 क्यों कर रहे हैं हम लोग? 2/3 तो
मालिक-
टोटल मेंबर्स प्रेजेंट होने चाहिए ना।
कितना?
2/3 should be the total members of the house present.
Present and voting. Yeah, present and voting. Yeah.
So हमें 2/3 तो 530 का निकालना चाहिए।
530 का निकालना चाहिए, right? Yes, yes. My mathematics is very bad. 530 का बट 530 में मैंने कहा कि 383 ने यस कहा है और बाद बाकी ने नो कहा है। यस, 533 का 2/3 निकालो, कितना होगा? My mathematics is very bad. Just if you help me in calculation. 3 से 176 into 2. $352. 352, am I right? Okay. So 352 अगर देता है and it is more than 50%, I think. Yes. Yes, 253 point आ रहा है तो 53. Yes, क्योंकि point यहाँ पे आ रहा है तो 353. So it will be passed. My God, I'm happy. Yes, I have calculated correctly. Anyway, so you got the point. Now, so if you see what are the matters apart from the this amendment, then removal of the Supreme Court judge and High Court judge. You know, in case of removal of Supreme Court judge, High Court judge, this kind of a special majority is also used. Okay. Any constitutional amendment other than federalism, right?
Sir?
That should, yes.
सर टोटल स्ट्रेंथ 545 की है लोकसभा की।
तो
इसका
353 हो रहा है तो ये 50% से ऊपर है।
हाँ, टोटल 50% से ऊपर है। हाँ जी, फॉर टोटल 50% होता है आई थिंक सो 273 हाँ 273 होगा। इसका पॉइंट में आएगा तो उसको 1 करके 273 कर देंगे। 273
कैसे होगा
सर? 545 का,
हाँ 545 का 273 तो यहाँ पर +2 + 1 होता है। ये देखिए 545 by 2 + 1 = 273. That is 50%, more than 50%.
यस सर,
राइट?
यस सर।
और यहाँ पर आइए तो यस 273 से ऊपर ही होना चाहिए, यानी कि 50% तो वही होगा, 273 होना चाहिए प्लस।
हाँ जी,
राइट। यस, आई वाज कंफ्यूज्ड।
ठीक है सर। तो इसके ऊपर ये भी होना चाहिए और 2/3 भी होना चाहिए।
2/3 भी होना चाहिए, हाँ।
लेकिन सर मैं ये चीज जानना चाह रहा हूँ कि अगर पार्लियामेंट के अंदर मतलब मान लो 400 लोग ही आए हैं,
अच्छा
ठीक है, और
निकाल लेते हैं हम लोग।
हाँ जी 400 लोग आए हैं और 350 लोगों ने मतलब पॉजिटिव उसमें यस में आंसर दिया है,
ठीक है,
ठीक है, तो ये तो 50% से ऊपर ही है ना, तो बिल पास हो गई।
बिल पास हो जाएगा, 2/3 भी है और 50%।
हाँ हाँ हाँ, बस मैं यही थोड़ा सा कंफ्यूज है। ठीक है सर,
2/3 भी होना चाहिए और 50% भी होना चाहिए। एवरीवन क्लियर? This majority as per Article 368. Okay. Now the third variation is, there are certain matter जिसमें हमें क्या चाहिए, 2/3 भी चाहिए एंड हाफ ऑफ द स्टेट का भी हमें सिंपल मेजोरिटी चाहिए, राइट? लाइक फेडरल मैटर, कोई भी फेडरल इशू है उसको उस पे लॉ बनाने के लिए 2/3 भी चाहिए प्रेजेंट इन वोटिंग एंड हाफ ऑफ द स्टेट, मतलब मोर देन नॉट लेस देन हाफ ऑफ द स्टेट का सिंपल मेजोरिटी चाहिए। तो 2/3 ऑफ द टोटल मेंबर, राइट, एंड not less than half of the state. state consent. स्टेट में कैसा कंसेंट चाहिए? स्टेट में सिंपल मेजोरिटी से पास हो जाएगा। स्टेट में मात्र सिंपल मेजोरिटी से पास हो जाए, बट यहां पर हमें चाहिए 2/3 of the total members and not less than half of the state. कोई भी फेडरल मैटर है या एक नेशनल जुडिशियल अपॉइंटमेंट कमीशन बनाया गया था 2015 में, राइट, बाद में उसको खत्म कर दिया गया। जुडिशियल ने बोला कि ये सही नहीं है, राइट। Judiciary asserted itself through the collegial system. The third kind of majority is a special type of majority is 2/3 of the total member of the house and not less than half of the state. यानी टोटल स्ट्रेंथ कितना चाहिए लोकसभा में? 364 एंड कितना 28 स्टेट्स हैं, तो 15 स्टेट्स का हमें वो चाहिए, एसेंट चाहिए। ओके, एलएस में कितना होगा? 2/3 364 एंड प्लस 15 स्टेट्स का हमें सिंपल मेजोरिटी चाहिए। Did you got the point? That is third kind of majority. If it is clear, then fine. Otherwise, let me know. Yes.
Sir, there is मतलब 15 स्टेट की मेजोरिटी चाहिए, मतलब कि वो उस बिल को लेके मतलब सरकार के साथ है, ऐसा कुछ?
उस वहां के असेंबली में वो पास हो जाना चाहिए।
अच्छा, स्टेट असेंबली में पास होना चाहिए।
Yes, yes. So 364 यहाँ पर और 164 राज्यसभा में, ये एलएस में और ये राज्यसभा में, इतने लोग वोट करना चाहिए, प्लस 15 स्टेट असेंबली में वो सिंपल मेजोरिटी से पास होना चाहिए।
ओके सर, ओके।
It's not political support. It must be passed in the state assembly. Right? So did you get the point? हमारे पास कितना स्टेट है? 28 स्टेट है ना यहाँ पर, मतलब 28 स्टेट है, 29 था 28, right? by 2 यानी कि 14, not less than, यानी 14 से ज्यादा भी चलेगा, 14 भी चलेगा। फोर्टीन से कम नहीं होना चाहिए। फाइन। Arinjay, did you get the point?
Sir, one clarification.
Yes.
Sir, when it says that not less than half of the state, sir, then how the state is going to give its consent? Through its own legislature?
Its own legislature, yes, with a simple majority.
Okay.
Fine. ऐसा नहीं कि चीफ मिनिस्टर ने बोल दिया तो हाँ, नहीं। It needed to be passed in the state legislature with a simple majority.
So जैसे वो CA और NPA वगैरह का हो रहा है,
Yes. Yes.
जब तक वो सब असेंबलीज में पास नहीं होगा तब तक उसको रोका हुआ है।
Right, right. सिंपल मेजोरिटी से जब तक वो पास नहीं होगा तब तक नहीं होगा। Now the fourth kind of a special majority, that is a special majority as per Article 61. Right. So Article 61, Article 368 and Article 249. And चौथा है जो अभी हम लोगों ने पढ़ा है immediately, for federal structure, to change the federal structure. इसमें क्या होता है? 2/3 members of the total strength. फाइन, यानी लोकसभा में 364 एंड राज्यसभा में 164। प्रेसिडेंट इम्पीच इसी आर्टिकल के से होते हैं 61 से। जो इम्पीचमेंट होता है उसमें 2/3 मेंबर ऑफ ईच हाउस, टोटल मेंबर ऑफ ईच हाउस मस्ट बी voted in support of impeachment, तब impeachment माना जाएगा। Fine, got the point? I'm moving to basic structure and it will take time. Basic structure हमारे पास अभी टाइम है, 20 मिनट तो है अभी, 20-22 मिनट, 25 मिनट। फिरोज, clear? So अभी confusion रहेगा, just you go and you look back the notes and clear it. If you have any confusion, we can clear it tomorrow also, no problem. But yes, you need to clarify each special majority. 3 आर्टिकल याद रखना है, आर्टिकल 61, आर्टिकल 249, आर्टिकल 368 एंड एक और याद रखना है, फेडरल मैटर्स। आर्टिकल 61 में 2/3 of the total members and a special majority as per article for federal matters, 2/3 of the total member present in voting and plus not less than half of the state, simple majority. फाइन, मेजोरिटी ज्यादा हो रहा है तो ज्यादा बोलूंगा तो आप ही कंफ्यूज हो जाओगे। You need to go and look back it, otherwise fine. So should I move to basic structure doctrine? Okay, this is a famous. Can I take 1 or 2 minutes to ask? Okay, Arinjay, can you tell me what is basic structure doctrine? I'll give you 1 minute.
Sir, it was proposed by as part of a Supreme Court, a very major landmark Supreme Court ruling made by Justice H.S. Khanna and others, where they
Khanna was CGI or Sikri?
I think he was he CGI? I think he was CGI. I think H.S. Khanna.
I think Khanna was justice. It was 13 bench, na? 13 judges bench.
Yeah, it was 13 benches. Yeah.
Right.
Yeah, Khanna was one of the members, but he was the one who explained about this basic structure doctrine.
Yeah. Khanna was right.
I think that was that was which P.N. Bhagwati or wait, that was that was another case.
No problem. Let me give. No problem. Just we are going to discuss it.
It was versus the state of Kerala, I think.
Yeah, that is the Keswanand Bharti case.
Keswanand Bharti.
No problem. Okay, Chaitanya, can you share some idea of basic structure doctrine?
Yes, sir. सर लाइक बेसिक उसमें ये भी है कि बेसिक स्ट्रक्चर जो है कॉन्स्टिट्यूशन का वो हम इरेज नहीं कर सकते।
अच्छा,
यस।
ओके दीपक, can you yeah 1 minute, what is basic structure doctrine?
That it is the basic tenet and the philosophy of our constitution that that should never be amended or changed, as told by by Sikri, CJI Sikri in case of
Sikri was CJI,
in case of Nanda Bharti case.
Right. Firoz? Yes, Firoz.
Sir, I have no idea about this.
No idea. Okay. No problem. I'm going to discuss it here. Prince.
Yes, sir.
Sir,
I think स्ट्रक्चर यस सर इसमें जुडिशरी का इन्वॉल्वमेंट होता है कि इंश्योर करना कि अमेंडमेंट की पावर मिसयूज ना हो रही हो पार्लियामेंट में आइडियाज और बेसिक स्ट्रक्चर ऑफ इंडियन कॉन्स्टिट्यूशन को किसी भी तरीके से मतलब कोई भी बिल ऐसा कुछ ना हो कि जो उसके अगेंस्ट जा रहा हो तो आई थिंक सो बस यही है
ठीक है ठीक
बेसिक स्ट्रक्चर
ओके ओके ठीक है अब देखिए मैं इसको कैसे आपको बताता हूँ आपको कैसा लगेगा अब सुनने के बाद बताना एक्चुअली आर्टिकल 12 और आर्टिकल 13 मैंने लिखा है वी डोंट नीड टू डिस्कस एंड यू नो आर्टिकल 12 एक्सप्लेन स्टेट डू आई नीड टू एक्सप्लेन स्टेट डिफाइन स्टेट आर्टिकल 12 and article 36 both define state right and basically article 12 right so any government and parliament of India any government or state legislature any local authority means municipality you know panchayati raj other authority means any authority where the government has said for example public school so public school would be state like ONCG you know ONGC LIC IFC are the example of state right fine so unaided school would be a state or not unaided
LIC
हाँ LIC भी स्टेट आएगा लाइफ इंश्योरेंस कॉर्पोरेशन ऑफ इंडिया
सर वो तो ठीक है लेकिन आई थिंक सो ये सेंटर होना चाहिए ठीक है आप बोल रहे हो स्टेट है
मैं केस बता रहा सुखदेव सिंह वर्सेस भगत राम सरदार सिंह रघुवंशी ये जजमेंट है सुप्रीम कोर्ट का मैं अपने मन से नहीं बोल रहा हूँ
ना सर ठीक है सर
सुप्रीम कोर्ट हेल्ड दैट बॉडीज लाइक ONGC क्या कि गवर्नमेंट का शेयर है इसमें स्कूल स्टेट है आप जो रोड पे चलते हो वो स्टेट है डोंट नो वेदर यू नो मीनिंग ऑफ स्टेट और नॉट जो आप रेड लाइट चलते हो गाड़ी चलाते हो और रेड लाइट पे रुक जाते हो व्हाट इज दैट इट इज a state fine
So,
so
then one problem there would be one problematic aspect also like Supreme Court can also be regarded as a state but
yes.
but sir state doesn't have a judicial side to it so that is why because it's the judicial side of the judiciary I guess that makes
judiciary also a part of the state it is
sir but according to the meaning of the article 12 of the Indian Constitution state is anything which has a law making authority
not law making law executing what is police
yeah law execute
police what is marriage officer
yeah
what is land record officer
even electricity boards
right so everything is state right जो एवरीडे स्टेट में हम लोग डेफिनेशन पढ़ाते हैं MCD यस स्टेट जो हम लोग एवरीडे स्टेट पढ़ाते हैं एवरीडे स्टेट का कॉन्सेप्ट है दैट मींस रोड जहां पर गवर्नमेंट का पैसा भी है तो भी स्टेट है कोई एडेड प्राइवेट स्कूल है will it be considered as a state Deepak?
yes sir it can be because it can execute its own laws
right so because there is a shares of the government it would be considered as a state
yes sir however if that's definition of a state which you give or which article 12 gives so if does the state also has the power to examine the law and to check upon its constitutionality
see there are difference between a state and government you have to make difference right
okay.
State is a permanent body right but government changes but government has three parts legislature executive and judiciary and the three organs of government has different kind of work Deepak, right so the only legislature and either of the India at the center or the state or the local authority the legislative part is responsible to make the law right like in the parliament, you know, Panchayati Raj, right? Gram Sabha, right? And the planning board, they have authority to make plan. Fine. So we need to differentiate between state and government. Final. Third, Article 13 क्या कहता है कि law inconsistent with or in derogation with of the fundamental rights would be null and void. Simple. So जो भी law independence से पहले थे और कब तक वैलिड थे, 26 जनवरी 1950 से पहले तक, जब कॉन्स्टिट्यूशन इन्फोर्स हो गया तो जितने भी लॉ हैं, इफ दैट लॉज आर इनकंसिस्टेंट विथ द पार्ट 3 ऑफ द इंडियन कॉन्स्टिट्यूशन, दैट वुड बी null and void, and the state cannot, you know, make law that would be inconsistent with the fundamental rights that is included in the part 3 of the Indian Constitution, that is Article 12 and 13. Okay, तो कोई भी लॉ जो वायलेट करता है फंडामेंटल राइट्स, वो नल एंड वाइड होगा. ये आर्टिकल 12 और 13 मैंने आपको समझा दिया. अब आइए हम समझते हैं बेसिक स्ट्रक्चर क्या है. बेसिक स्ट्रक्चर में ये मत लिखना, यहाँ पे आना. और हु इज द कस्टोडियन ऑफ द कॉन्स्टिट्यूशन? आई नीड आंसर फ्रॉम योर साइड, जल्दी जल्दी. और द पार्लियामेंट.
वो आर्टिकल 13 का आप महत्व समझा सकते हो? Because I kind of missed out on that.
Article 13 का,
why was it mentioned there?
sorry, I didn't get your point. What you're asking? You're Arinjay? Your voice is not coming to me. Network issue. Yes, it is network issue. I'm unable to. Arinjay? Okay. We are unable to listen him. Okay, anyway. So listen, the Constitution. Who is the custodian of Constitution? Who is the final interpreter of the Indian Constitution? SC, as you already said. But who made the Constitution?
Yes, I just got disconnected. I'm back.
Yeah. Yes. Arinjay, tell me.
Yeah, I was asking about Article 13, sir. What was the significance of that? I missed out on it. काफी network issue है वैसे.
मेरा नेटवर्क इशू तो है. आप क्या पूछना चाह रहे हैं?
Article 13 के बारे में सर. What was that in context? In what context was that presented, sir? मतलब what does it signify here?
Article 13 says any law in the past, in present and future, if it is not consistent with, not concurrent with the fundamental rights that is included in the part 3 of the Indian Constitution, would be null and void. Right? Any law in the past, present and future, if not consistent with the fundamental right, not concurrent with the fundamental rights included in the part 3 of the Indian Constitution, would be null and void. कोई भी लॉ, ऐसा लॉ, चाहे वो इतिहास में रहा हो, चाहे वर्तमान में, चाहे भविष्य में, यस नेटवर्क इशू है, अगर वो फंडामेंटल राइट्स के अकॉर्डिंगली नहीं है, अगर वो फंडामेंटल राइट्स को वायलेट करता है, वो लॉ नल एंड वाइड होगा. Okay, Arinjay? Did you get the point?
Yeah, thank you.
Okay. So now we have 10 minutes and I'll explain in 10 minutes. No problem. See, यहाँ पर ये जो झगड़ा था, the quarrel between the Parliament and the Supreme Court was for the custodian of the Indian Constitution. Who is the final authority of the Indian Constitution. So, you know, the Constituent Assembly member established independent Supreme Court as a custodian of Indian Constitution and final interpreter of the Indian Constitution, right? Constituent Assembly, the framer of Indian Constitution, established an independent constitution, Supreme Court to interpret the Constitution and to protect the Constitution also, right? कि Constitution में कुछ damage ना हो जाए. Secondly, the Constituent Assembly also gives Article 368, that means power to the Parliament to amend the Constitution, right? Any part of the Constitution. So here the power struggle, power conflict between Supreme Court and the Parliament. Who is the final, you know, whose supremacy will prevail? Whether Supreme Court supremacy will prevail or the Parliament supremacy will prevail, right? So if you see the earlier, you know, judgment of the Supreme Court, like Shankari Prasad case in which the first Constitutional Amendment Act was challenged, right? What happened in first Constitutional Amendment Act? It created 9th schedule, right? And there was a, you know, so first Amendment Act was challenged, and the Shankari Prasad case, in Shankari Prasad case, Supreme Court says that the Parliament has power to amend the Constitution, right? So law within the Article 13, the law within the Article 13 does not include Amendment Act, because Constitutional Amendment Act, it is a Constitutional Amendment Act, it is not law. So they upheld the Constitutional Amendment Act and, you know, gave the assent to the Parliament. Yes, you have right to amend the Indian Constitution, including fundamental rights. Okay, so law mentioned in the Article 13 is not, or you know, it means ordinary law, not the Constitutional Amendment Act. Fine, the first step of the Supreme Court. First step of Supreme Court was that the Parliament has power to amend the Constitution, including fundamental rights. The law mentioned in Article 13 means ordinary law, not the Constitutional Amendment Act. Okay, but in Golaknath case, this Shankari Prasad case, you know, judgment was repeated in Sajjan Singh case. Okay, but in Golaknath case, the Supreme Court, you know, just reversed the earlier judgment, and it said Parliament cannot touch the fundamental rights because Constitutional Amendment Act is also a law. यहाँ पर law का matter था कि law क्या है, right? So law mentioned in Article 13 is also, it means also Constitutional Amendment Act, right? So that is Golaknath case. बिल्कुल मना कर दिया, you cannot change the fundamental rights. अब Golaknath case के बाद, yes, Arinjay.
Right, interrupt, sir. Just a question. So in the previous Shankari Prasad case, when they meant ordinary law, that did not include any amendment made using Article 368.
368, right?
And in Golaknath, they say that even that will be included. Any constitutional
Yes.
amendment that
Yes.
act what its provisions will also be considered as ordinary law. So
Ordinary law mentioned in Article 30 means also constitutional amendment.
okay, earlier Article 13 did not touch Article 368.
Right.
Any laws made under Article 368.
Earlier law means ordinary law. Here law, they have expanded the view of law. Law means ordinary law plus CAA.
Understood. Thank you.
Got the point? Okay. Right. So now the Parliament reacted to the Golaknath case. ये तो बहुत supremacy हो गई SC की. राइट, कि पार्लियामेंट को चैलेंज कर दिया कि पार्लियामेंट कैन नॉट अमेंड द फंडामेंटल राइट्स, राइट, यूजिंग आर्टिकल 368. नाउ इन केस दे पार्लियामेंट अमेंडेड आर्टिकल 24. Sorry, Parliament did amendment 24th amendment CAA, and now you see उन्होंने क्या किया, आर्टिकल 368 को ही अमेंड कर दिया, जो मैंने आपको पढ़ाया आज कि आर्टिकल क्लॉज 1 को भी मॉडिफाई कर दिया, 2, 3 को ऐड कर दिया, किसमें, 24th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट में. आर्टिकल 13 के क्लॉज 4 को डाल दिया और कहा no constitutional amendment act will be challenged. Right? So see the conflict. Right? And interestingly, in Keswanan Bharti case, the 13 judgment, 13 judges bench, sat. And 6th was in the support of, जो 6 था उसमें ये support करता था कि okay, parliament can change the amendment any part of the Indian Constitution, including fundamental rights, preamble, anything. जो 6 था वो ये कहता था कि no, Indian Parliament can amend the Constitution but cannot touch the fundamental right. एक था, that was Chief Justice Sikri, and he was in view that the Parliament can change any part of the Constitution, including fundamental right or preamble, whatever, but it cannot damage the basic features of Indian Constitution. So सात लोग हो गए, मेजोरिटी ये हो गया, yes can change, but यहाँ पर ये था कि इन्होंने no कह दिया, क्या no, basic structure को damage नहीं कर सकते, right? So in Keswanan Bharti case, the Supreme Court, the majority of the Supreme Court, that was 7:6, says that the Parliament can amend the Indian Constitution, including fundamental right and the preamble of Indian Constitution, but cannot touch the basic structure of the Indian Constitution. Right? So basic features of Indian Constitution. इतना समझ में आया? Did you get this point? Just unmute yourself and just have conversation. Firoz, did you get the point? Unmute yourself. Tell me what is basic structure doctrine, if you got the point. Yes, Firoz. No, not yet. Okay, Prince, you tell me. What is basic structure doctrine? Yes, if you got the point.
So yes, बेसिक स्ट्रक्चर डॉक्ट्राइन सर, जैसे आप बता रहे हैं डॉक्ट्राइन में, मतलब कि काफी जैसे फर्स्ट अमेंडमेंट में हुआ कि आप कर सकते हैं लेकिन फंडामेंटल राइट्स को नहीं छेड़ेंगे, तो लेकिन उन्होंने कहा कि कुछ भी अमेंडमेंट करो, चाहे फंडामेंटल राइट्स के साथ करो, चाहे प्रेम्बल के साथ करो. देन उसके बाद फिर वो सीकरी जो आपने जज बताए कि उन्होंने बोला कि नहीं, फंडामेंटल राइट्स को कुछ भी नहीं कर सकते, बाकी अमेंडमेंट जो भी कॉन्स्टिट्यूशन में करने हैं आप करिए.
आपको 3 जजमेंट का नाम लेना है अगर बेसिक स्ट्रक्चर डॉक्ट्रिन आता है तो, ठीक है. और पहला लाइन लिखना है कि द सुप्रीम कोर्ट इज द कस्टोडियन एंड गार्जियन ऑफ इंडियन कॉन्स्टिट्यूशन.
ओके सर,
राइट. सो और इन द शंकरी प्रसाद केस, सुप्रीम कोर्ट said that parliament has power to amend the Indian constitution including fundamental right, but in Golaknath case, the Supreme Court reversed the judgment. Right? इतना लिखने के बाद फिर लिखेगा केशवानंद भारती केस, that Supreme Court held that the Parliament has power to amend the constitution under Article 368, but it cannot damage, it cannot change the basic structure of the Indian constitution. Now, what is basic structure? आगे फिर आपको लिखना पड़ेगा what is basic structure. what is basic structure? Right? The later judgment of Supreme Court, the later judgment of or judgments of Supreme Court or the SC declared that features like secularism, federalism, rule of law, right? और बोलो तुम लोग election, free and fair election, right? Democracy, Article 32 and Article 226, right? All are part of the basic structure. So आप लक्ष्मीकांत में एक पेज में पूरा का पूरा जजमेंट और ये दिया हुआ है कि किस जजमेंट में बेसिक स्ट्रक्चर क्या था. Got the point, Deepak?
फंडामेंटल राइट्स बेसिक स्ट्रक्चर के डॉक्ट्रिन में आते नहीं सर.
फंडामेंटल राइट भी बेसिक स्ट्रक्चर्स है. आर्टिकल 21
तो सर ये जो इनका 73 में जो जजमेंट था, isn't that kind of contradicting their claim कि they can change, the parliament is entitled to change the fundamental, मतलब bring some amendment in the fundamental rights, but it cannot touch the basic structure. But basic structure तो
it indirectly says that Parliament has the authority to change the constitution. Basically, indirectly, I'm telling you. But the Supreme Court has asserted after decline of Congress, right? So if you see the SR Mumbai case, Mindra Mills case, Indira Gandhi versus Raj Narayan case, Vaman Rao case, जब decline होता है तो Supreme Court assert करती है. Right, this is basic structure, this is basic structure, this is basic structure. Okay, so there are so many features that has already been declared as a basic structure doctrine through the different
structure. It is not, it is dynamic, बदलते रहता है as per the interpretation of the Supreme Court.
Now, if you see the Supreme Court, the SC is silent on abolition of Article 370. It is a federal matter. Right? So constitutional bench must declare it whether abolition of Article 370 is constitutional or not, because this is the basic features.
Sir.
Yes.
Sir, but what if the changes that is being made in Article 370, so it is put under the purview of Schedule 9? Sir,
then Supreme Court review. मैं आगे और लिखा हूँ, नहीं लिखा हूँ. See, Article 24th April 1973 को जजमेंट आया था. किसका? केशवानंद भारती का.
Yes.
जो भी एक्ट, जो भी लॉ 24th अप्रैल 1973 के बाद 9th शेड्यूल में रखा गया है, सुप्रीम कोर्ट कैन रिव्यू दैट लॉ. फाइन दीपक?
Yes, sir.
Okay.
Could you repeat the last point? Like you said, it can review what all laws?
He asked that, consider that Parliament has abolished Article 370, right? A special status to the Jammu and Kashmir, but it damages federal structure, right? But what if the Parliament, keep it in the 9th schedule? So before 24th April 1973, there was a law that Parliament cannot touch 9th schedule. Ninth schedule, right? But after 24th April 1973, Parliament can touch the article, any law that has been included in the 9th schedule, and that judgment has come in 2007. Can you remember that judgment?
I don't remember the name, but sir, one
was that MC Mehta case?
I have to check.
Yes, I have to also check.
Sir,
yeah,
one confusion, sir. So in Schedule 9 in the 2007 judgment, the judiciary said that it cannot review all the law that has been put in the purview of this one, Schedule 9.
Okay.
Only those laws in Schedule 9 since 24 April 1973 that are violating fundamental rights can be reviewed by judiciary.
That is unconstitutional, simply.
Yeah,
if that is unconstitutional. Yeah. So all law that has been put after 24th 1973, and if that is violating Indian Constitution, then that law can be reviewed by the Supreme Court.
Yes, sir. अब question actually ये था sir कि मान लीजिए जो Article 370 को repeal किया, so that is not a violation of fundamental rights, right? That is just a violation of a
Constitution, federal structure. Right.
Federal structure. सर तो अगर उसको शेड्यूल 9 में रखा है तो इस जजमेंट के हिसाब से क्या जुडिशरी उसके ऊपर कुछ बोल सकती है? कैन इट रिव्यू?
Yes, it can. Why not? It's not only those law which violates fundamental rights.
Okay.
It also violates basic structure, man. The SR Bombay case.
Okay.
As what SR Bombay judgment? In SR Bombay judgment, the two things which is basic features of Indian Constitution. One is secularism and other is federalism. So here federalism is being damaged. So it can review. Okay. It can see the constitutionality. Fine.
Clear, sir.
We'll carry tomorrow. Okay. See you tomorrow then, and we'll carry discussion on it.